I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And this is a Friday night special. And you know I like to do the specials. And in this one, I'm going to try to keep it action-packed for you because we have had just the most obscure but explosive update hit the court docket that I can remember in a long time. And most people won't understand what they're really looking at. But I assure you, you will understand because I'm going to break it down for you, and it is huge. We're also going to get into some other information. I might do a little bit of ranting on this thing for you tonight because of some things that I heard mentioned here recently in a video by another content creator, and I just can't let that stand. So I might do a little rant on it. And then I'm going to give a little bit of a history lesson because in my video that I did yesterday, I had one gentleman in there. I don't know if he was just a straight up guilter or a troll or whatever, but kept repeating himself or herself over and over and over, which is, show me the proof of what you're talking about, Pavarotti. I want to see the proof, Pavarotti. Oh, really? You want to see the proof of what I'm talking about as it relates to the confidential informants, huh? Okay, well, I'll be happy to do that for you. And at the same time, I'll show you the proof they had against Bryan Kohberger when they arrested him. So based on the proof that they had against Bryan Kohberger when they arrested him and what I'm going to show you in this video about the confidential informant in the case, whether or not he should be included as an alternative perpetrator and accepted as an alternative perpetrator defense by the judge, I'll give you the evidence side by side and I'll let you decide. And one other thing I do want to mention, okay, because I know sometimes it does get confusing when I talk about these confidential informants in the Kohberger case. You know, it's been my determination of what I've investigated for some time now. Started out thinking Kohberger was the hitman, him and Kopacka. As I dove deeper and deeper and deeper, I realized, well, they're not the hitmen. One thing that doesn't change, though, in my investigation is that's the fact that confidential informants did name them. I believe they initially named Kopacka, and then they got to Kohberger. Kohberger may have been known by them as well, though, as they, spun their little tale. And I believe that they investigated Kopacka to the point where they made Kopacka make them shoot him. And then as they continued investigating Kopacka, I think they may have come across something that either excluded Kopacka from the crime because you have to think about this stuff in the right way. If Kohberger and Kopacka aren't guilty, like I've been saying now for almost a year, but they were set up for the crime, well, you've got to understand, when investigated, they didn't do it. So it's logical to think that at some point, law enforcement may have found something that excluded Kopacka. They just didn't find enough to exclude Kohberger. Or if they did, it's too late and they're already, gone this far and they're trying to get this case closed. And if it's my assumptions and my investigation and the things that I've seen are correct, if Kohberger was using, well, then they have no qualms with convicting him, whether he's guilty or not, because it's been done about 1 trillion times in this country. And I could name case after case after case. But when I talk about these confidential informants and what they would be testifying to, they're not going to testify. Well, let me back up. They're not going to truthfully testify to seeing Kohberger at the crime scene, right? And those aren't my words. Those are Bill Thompson's words. All you have to do is go find the response to the alibi in April of 2024. And Bill Thompson clearly lays it out in writing that if Kohberger's allowed to bring forth evidence of an alibi, then he'll need additional time to put together a list of witnesses to place him at the scene. It happens in cases every single day, major cases especially. They will take people and put pressure on them, and it's usually criminals, and those criminals will get on that stand and they will lie over and over and over again. And if they can't find somebody on the outside that can do it, then they'll go get somebody in the jail, put them on the stand, and they'll lie and testify to what they told them in the jail. Happens almost every case. And I can give you example after example. If y'all want them, I'll show you the actual testimony, and then I'll show you the actual video of them saying that they did it. They lied because law enforcement pressured them to. So that happens every day. But what we're going to talk about first in this one, before I get too far into my rant, is the huge order that just came through from Judge Hippler in this case. Hold on to your hats. Now, this is where you really have to almost be a court doc detective to figure out what's going on, because they keep everything under wraps, but sometimes they give us just enough information to clearly figure out what the game is. And on June the 2nd, the defense out of nowhere files a 23rd supplemental request for discovery. And in that 23rd supplemental request for discovery, June 2nd, they said that pursuant to Rule 16 of the Idaho Criminal Rules and of the Articles of the Constitution, that the defense requests all materials discoverable by the defendant per ICR 16B1 through 8 and the aforementioned constitutional provisions, but then they cited the information, evidence, and materials outlined in Exhibit 5. Now, Exhibit 5 is under seal, but we know this is a really, really big deal, because whenever they're filing for filing for something under discovery, they're wanting something specific. It has to do with Rule 16, specifically B1 through 8. So you have to be familiar with B1 through 8 to know what the possibilities are. So when we go over here to 16B 1 through 8 of the Idaho disclosure rules, it talks about 16B 1, which is the statement of the defendant. I'm not going to go through all these. Statement of co-defendant, defendant's prior record, documents and tangible reports of examinations and tests. A lot of people think it's that because of what they've gone through with the mental health evaluations. But I'm going to tell you that what it relates to is either going to be number 6 here or number 8 here. And I'll prove it before this video is done. Number 6 is state witnesses. On written request of the defendant, the prosecuting attorney must furnish to the defendant a written list of the names and addresses of all persons having knowledge of relevant facts who may be called by the state as witnesses at the trial, together with any record of prior felony convictions of any of them. That is within the knowledge of the prosecuting attorney. The prosecuting attorney must also furnish on written request the statements made by the prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agents or to any official involved in the investigation, which means the FBI as well, of the case, unless a protective order is issued as provided in subsection L of this rule. What I'm going to show you is there was a protective order issued for the information that the defense is wanting to get from the state on this particular subject. I'm going to show you what it's going to be. And then on number 8, it either has to do with a secret testimony of one of the confidential informants or a secret police report that was not disclosed to the defense due to one of the confidential informants. And this is something that I've been waiting for them to bring up, because in their original motion to preclude the death penalty, they hit hard in that motion on the failure of the prosecutors to include all Brady material. And they cited specifically that they were using another investigative organization, the fact that the FBI investigation was separate from the local guys in, as reasons for not disclosing this information. And they hit it hard. I mean, they were Brady. But then when we got to the rebuttal and the oral argument, they took out all of the Brady stuff and everything I'm talking about now. And even the judge mentioned that you're not even talking about the Brady issues. You're talking about now due process issues. So they took it out, and whenever they do that, it's my experience with them that they do it for a reason, and they do it to bring it up later in a different way. So I'm thinking this might be them bringing that up now, but I'm going to show you what this all means. Now we have to follow the progression of this motion to understand that it's a really big deal, and I'll show you why we know that. Here is the state's initial response, and they did one of their boilerplate responses, except something weird right here. I've never seen the responses say to the defendant Bryan Christopher Kohberger and counsel Ann Taylor. It's usually to the, just to the defendant. So that's weird. That's different. But this is one of their boilerplate responses. The state of Idaho, through the prosecuting attorney, submits Exhibit S1, and that's the same exhibit that they issued back in January of 2023, I believe, filed under seal in response to defendant's 23rd supplemental request for discovery filed on June 2nd. The state has and will continue to provide discovery in accordance with Idaho criminal rule and applicable law and reserves any and all objections thereunder. So boilerplate answer, but we know it's a big deal because it didn't stop there. Now, normally when the defense files a supplemental request for discovery, the state just responds with that boilerplate response, and that's the last we see of it. This one is different, though. You can see just yesterday or day before yesterday, the prosecution took it upon themselves with no other anything coming from the defense that hit the court dock to supplement that response for defendant's request for discovery. So this is their second response to that request. That tells us that there's something different about this request. And again, it's titled weird just to defendant Bryan Christopher Kohberger and counsel Ann Taylor. But it says, comes now the state of Idaho by and through Latah prosecuting attorney and hereby supplements its January 23rd and September 4th, 2024 responses with Exhibit S1 filed under seal in response to defendant's request for discovery pursuant to Idaho Criminal Rule 16, filed on January 10th, 2023. The state has and will continue to provide discovery in accordance with Idaho Criminal Rule 16 and applicable law, but then they added this extra statement, and reserves any and all objections thereunder. So they'll provide discovery in accordance with Idaho Criminal Rule 16 and applicable law, but they're going to reserve any and all objections thereunder, which means they can object to disclosing certain evidence. Now it gets a little bit more interesting. But then we see this order sealing Exhibit S1, RE, the state supplemental response to defendant's request for discovery. And it says, based upon the state's motion to seal Exhibit S1, RE, state supplemental response to defendant's request for discovery filed herein is exempt from disclosure and is sealed pursuant to Idaho Criminal Rule 32G1 and Idaho Code 74-124C for the reasons stated in the said motion and until a hearing can be held on the matter, which is very strange. Until a hearing can be held on the matter. And what's weird is I didn't see any hearings held on the matter. It looks to me like Judge Hippler has just ruled in favor of the defense being able to access this information. Because this was 6-4-25, but you got to look at Idaho Administrative Rule 32G1 and 74-124C. And it was something that was apparently so important. The judge was talking about having a hearing held on the matter. And what could that mean? Because normally it has to get all the way to a motion to compel before a hearing is held, not just a supplemental request for discovery. But this one was so important, the judge was saying we're going to have a hearing held on the matter. I don't think that happened, though, because it looks to me like he just went ahead and made his ruling. And for once, his ruling was for the defense, it appears. All right, so this was filed June 5th. Ada Court, District Court, State of Idaho plaintiff versus Bryan C. Kohberger defendant. and this is an order by Judge Hippler. The order granting access to sealed records dated June 5th, 2025, is sealed pursuant to Idaho Court Administrative Rule 32G1, 32I3A46, and Idaho Code Title 19, Chapter 11. It is so ordered, dated this 5th day of June, 2025. And let me put it this way. The state already has access to the records that the judge is unsealing for the defendant. The defendant hasn't had access to those records, though, because it's been brought up in court many times. Now, you might ask, well, what are they granting access to? This right here tells us exactly what they're granting access to. Let's take a look, because this gets really interesting. First, let's look at Rule 32G1. Okay. Rule 32. All right, 32. The Idaho Court Administrative Rule 32. Records of the Judicial Department, examination and copying, exemption from, and limitations on disclosure. Now, when it says disclosure, that means limitations on disclosure. That means the prosecution disclosing the information to the defense. And this is a sweet day for me, because back when I've gone over this many times, I would have my trolls make videos and say, no, Pavarotti, that's not what that means. Ha, 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 and laugh at me and say that was disclosure to the public. The defense had access to it. Well, here's the proof in the pudding. The judge just granted the defense access to it yesterday. So you're wrong, I'm right again. Thank you now. 32G1. Oh, let's see. E, F, G, A, B, C, D, E, F, G. Court records exempt from disclosure. It means exempt from disclosing from prosecution to the defense, except as provided in paragraph H of this rule. Court records specified below are exempt from disclosure. Any willful or intentional disclosure or accessing of a sealed, shielded, or exempt court record not otherwise authorized under this rule may be treated as a contempt of court. And he said G1, and that's documents and records to which access is otherwise restricted by state or federal law. So I wonder what kind of documents and records that he's talking about. It must be serious, because they're restricted by state or federal law. And what else did he say? 32I3 A, 4, and 6. I3 A, 4, and 6. Here we go. The records contain facts or statements that could compromise the security of the judicial branch personnel, property, or sealed or exempt court records maintained by the judicial branch. 6. That it is necessary to temporarily seal or redact the records to preserve the right to a fair trial. Okay, well, that tells us a little bit right there. But let's go ahead and look at what else he cited. Idaho Code Title 19, Chapter 11. What does that mean? Let's look at the overview here. Idaho Code Title 19, Chapter 11 outlines the powers and duties of the grand jury in Idaho. It covers a range of topics, including evidence, procedure, and secrecy of proceedings. Okay, because, the defense has been wanting to get the entire grand jury transcript since the beginning and hasn't been able to do that. And key areas covered in Title 19, Chapter 11 include: this section defines the general scope of the grand jury's authority, including the ability to inquire into public offenses and present findings to the court through presentment or indictment. Okay. The chapter clarifies what evidence is admissible before the grand jury, including witness testimony, documentary evidence, and depositions. It also addresses a situation where a witness's prior testimony at a preliminary examination may be considered. Okay, so you can bet this is going to have something to do with a witness. Chapter 11 specifies the standard of evidence required for the grand jury to return an indictment. Yeah, well, they've already litigated that. The chapter establishes the process for appointing a special inquiry judge to conduct investigations into suspected crime or corruption, including, the judge's powers and the rights of individuals who are called to testify. So, interesting there. Chapter 11 mandates that grand jury proceedings be kept secret and outlines exceptions to this rule, such as when testimony is needed to determine perjury or consistency with court testimony. I wonder what the judge has unsealed in this one. The chapter addresses situations where a witness may be incriminated by their testimony. It allows for the grant of immunity. It allows for the grant of immunity and the possibility of compelling testimony with certain limitations. You think they granted one of those secret witnesses immunity? Section 19.1111 specifies who may be present at a grand jury session, including the prosecuting attorney, designated district court reporter, and the grand jury members themselves. So Bill Thompson, huh? The chapter also includes sections on the foreman's authority to administer oaths, the duties, and disclose knowledge of an offense, and the grand jury's access to prisons and public records. What went on in that grand jury, do you wonder? Let me go ahead and wrap this in a bow for you, and then I'm going to discuss briefly those comments by another content creator, and then in tomorrow's video, I'll get into the proof of the confidential informants related to the proof against Bryan Kohberger and let y'all decide on that one. But to wrap this all in a bow, because this is huge, since the beginning, and I've gone over this in court documents for quite a while now, the defense has been after the full grand jury transcripts. They've been unable to get them because John Judge issued a protective order over some aspects of those grand jury transcripts. The defense has been after them for a long time, and they have been held at bay. It looks to me like whatever they filed in their Exhibit 5 of this supplemental request for discovery put the prosecution on its back heels, because they filed not just one, but two responses to that supplemental request for discovery. And then in the motion to seal it, the judge even specifies we need to hold a hearing on this matter. Yet the very next day, instead of having a hearing on the matter, he issues an order granting the defense access to those records that they've been trying to get now for almost 2 years. This is huge, because whatever the prosecution was hiding from the defense in those grand jury proceedings, they now have in their hands. And you can bet, I've said this 100 times, what they were after, because when you watch the progression of, guess what? The alibi, what the defense started out saying in their alibi responses was they would have a corroborating witness that was a witness for the state that would partially corroborate Bryan Kohberger's alibi. But then later on, after they couldn't get access to the grand jury transcripts, the full transcripts, they no longer added that caveat to their alibi responses. And it was my assumption that because they couldn't get access to the grand jury transcripts, that they gave up on that particular state witness corroborating that. But now that we're getting into the time where I predicted that the alibi issue was going to come up, now we see a supplemental request for discovery that the judge actually grants access to. Again, fireworks are in the midst, folks, and I can't wait. Now, let me address this. I'm sure not too many people out there seen it, but the ones that did, a content creator who supposedly believes in, being on the middle of the fence and innocent until proven guilty, for some reason has a big problem with the alternative suspect defense the defense is bringing. I personally know why they have the big problem with it, because me and that particular content creator actually went back and forth quite some time ago on the alternative perpetrator defense, long before the defense ever filed an alternative perpetrator defense. And his position was they would never file one because basically it was just trying to down my investigation into the case. Now that the defense has absolutely filed one, you can bet he is on edge. So he doesn't want this alternative perpetrator defense, even though he's supposedly on the fence of the thing. So what was he trying to say in a video? Blew my freaking mind. First of all, he tried to say that why would the defense even put forth the alternative perpetrator defense? If they were smart, they would hold it back till trial and use it against them. Well, guess what? Since the prosecution filed a motion in limine to exclude the alternative perpetrator defense, if the defense did not file an alternative perpetrator defense, if they tried to bring it up at court, even laying proper foundation, the prosecution would object and the judge would sustain, and they would never be able to bring up any of it because of that motion in limine. So because the prosecution filed a motion in limine, the defense had to offer the evidence and get it approved before trial so that they can bring it up. So that wasn't very bright of him. But number two, my head exploded. This is why I've got to bring it up. Because this person has been in prison for 20 or 30 years. I don't know how long. So he knows how prison works. And he made the assertion, literally said this. Now, I've never been to prison, but I'm not a moron, okay? A moron, not in all cases anyway. He said that because the defense was bringing up an alternative perpetrator defense, and because if you were convicted, when you get to prison, you have to show the other inmates your paperwork to make sure that you're not a snitch. He suggested that by the defense bringing up an alternative perpetrator defense, that the inmates, if he was convicted, would look at him as a snitch for doing that. Number one, any paperwork that you would have going into prison, I would assume would list your charges and maybe your sentence or something. It certainly isn't going to list the type of defense that you presented at your trial. Oh, look, here's my paperwork, other inmate. Oh, I see here that you utilized the alternative perpetrator defense at trial. We consider that snitching. We're going to get you. Give me a break. That was the first moronic thing that was said. But the other part to that is the dumbest thing I've ever heard in my life is when you bring forth an alternative perpetrator defense, it's because your defense team and its investigators that it employed investigated the leads that were presented to law enforcement and came up with an alternative perpetrator defense. You didn't sit in jail and say, hey, look, I don't know who did it. Let's go ahead and use that as our defense. If you actually knew that, you would have already given it to the state, and then you really would be a snitch. But in an alternative perpetrator defense, it is brought up in any case that there's an alternative perpetrator. It has nothing to do with snitching, and there's nobody in a prison that would ever know that your defense team used an alternative perpetrator defense at trial. And no, you don't come up with alternative perpetrator defense issues, hand it to the prosecutor, and then they let you out and go arrest them. That's not how it works either. You're on trial. They brought forth evidence to put you on trial. If you bring forth an alternative perpetrator defense, here's what it allows you to do. And this is all that it allows you to do. It allows you as an attorney during the opening statement to paint a picture of somebody else that had actually committed the crime other than your client. As an example, you heard the prosecution just say that my client did this and this and this and this, and that is not at all what happened. Here's what really happened. This person did this and this and this, and I believe the evidence is going to show that. And then in closing statements, you get to make those charges again. And then as you're questioning witnesses, you get to present it in the way that somebody else did it. That is how that works. Not, alternative perpetrator defense, go arrest them. And by the way, now you're a snitch. Give me a break. That is the dumbest thing that I've ever heard in my life. And anybody that heard that and soaked that in, I assure you, you don't have to go to prison to know that that is stupid. And that is not how it works. And if I need to go find an inmate to verify that, believe me, I will, but I don't have to because I've got a brain. And anybody that says that, they know they're lying. It's not that they're dumb. They're lying because they're scared of what they said in the past, actually just slapping them right in the face, unfortunately. And I had to get that out because I've never heard something that stupid in my life, that if your defense team brings forth an alternative perpetrator defense, then you're going to be found to be a snitch in jail and you're signing your own death warrant. Give me a break. If anything, I would consider that to be almost, witness intimidation to even put that out on the airwaves. Because, if the wrong person heard that, that would be almost like intimidating the defense team not to bring forth alternative perpetrators. I'd be careful with statements like that. Tomorrow, we're going to get into some seriousness, as I mentioned in the beginning of this video, and then I've got so much more to bring you. But before I do that, I do want to bring up one thing about my video yesterday. And for those of you that are watching me from the beginning, you know how profound it is. For those of you that haven't, you probably don't even understand how profound the Farley situation really is. And here's why. I looked up the dates on my initial video where I discovered those folks. And here it is right here. And it was back in March of 2024. And after that, I proceeded to do probably 100 videos trying to connect them to the parents, that's when I came across the Aryan trafficking organizations, and I spent a lot of time connecting all of those groups. One thing I could never do, though, is I could never actually place them at the scene of the crime. I found them, put all that together without ever placing them there. Didn't believe I would ever be able to place them there. But I'll be danged if several months later, the amazingly great Bubbly Waters listened close to some Linda Lane footage and deciphered that they weren't saying, "I see you, Charlie." They were actually saying, "I see you, Farley." And that was after I'd put it all together. She placed him at the scene. So for me to find those folks the way I did, put it all together, figure out half of the court case based on the dates of their arrest, and then Bubbly finds him at the scene of the crime the night of the atrocity. You don't think that is profound? You don't think it's real? That was the biggest piece of corroborating evidence that I could possibly imagine. And you know what? Let's just go ahead and I want to bring this up too while I'm on here doing a big rant. Because one video that I did that made a lot of other content creators out there really their heads explode. And I played it again here recently. And that was the change of venue hearing by the defense, where Ann Taylor, who had control of the guy's laptop, put all the videos on the screen for everybody to see. And it just so happened to show 3 of my videos on that screen. And I showed y'all that, and here's the thumbnail for it, right? And I said, "Thank you, Ann Taylor. I appreciate the shout out." And everybody thought I was crazy and I'd lost my mind. But one thing that everybody seems to forget, that remembers when that happened in real time, wasn't that video where she showed 3 of my videos prominently on the screen. It was the video that I had done the day before, where I actually did a video and I asked Ann Taylor to send us a shout out to make sure that we were moving in the right direction with our investigation. And then the next day in that hearing, when she popped up those videos, I went, oh, wow, there it is right there. So you remember, people don't remember this one. So it wasn't just Ann Taylor popping up the videos on the screen. It was the fact that I asked for an actual shout out before she did that. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.